Saying I was acting in self-defense in California does not guarantee your freedom. Here's what California law actually requires. Hi, I'm Nana Knight, and I've spent over 16 years in the courtroom, first as a prosecutor and now as a criminal defense attorney who's also certified by the California State Bar Board of Legal Specialization. If you have an urgent need to speak with an attorney, call us at Knight Law at 408-877-6177. In California, there are three core elements that you have to prove as part of your self-defense. First, you must prove that you or a third party were in imminent danger of suffering great bodily injury or death under the circumstances. Second, you must prove that your belief was actually reasonable under the circumstances. So the courts are going to look to see if your fear of suffering great bodily injury or an imminent risk of suffering great bodily injury was actually reasonable under the circumstances. And then the third is that you have to show that the force that you used in self-defense was no more than necessary than to actually meet the threat. So if somebody's coming to you to maybe slap you on the face, you can't just grab a gun and shoot them, right? That would be considered excessive force. It would be considered unreasonable force, and you would likely not have a very effective defense of self-defense. So these are the three core elements that you have to keep in mind when you're dealing with the defense of self-defense in California. And just the other thing to keep in mind is if you can prove all of these elements, then the self-defense is a complete defense to whatever crime you're charged with. So where most self-defense claims fall apart is based on the reasonable person standard, right? So would a reasonable person feel the same threat or feel the need to use the same amount of force that you used in the circumstances? This is the yardstick that courts are going to use to assess your situation, right? So they're looking to see how the harm was presented to you. Was the person who is threatening you physically bigger than you? Were they using a weapon? And if so, what kind of weapon was used? Did you have an opportunity to retreat? Was the risk of the injury so imminent that it left you with no other way out? These are all things that are going to go into the courts or the jury's assessment of whether your belief in that risk of being threatened by grave bodily injury or death was reasonable under the circumstances. So your self-defense, your testimony, of course, is important, right? The jury is going to want to hear that. The judge is going to want to hear that. Your defense attorney has to find a way to present your claim of self-defense, and that's usually through your testimony. But you also have an absolute right not to testify, and the jury cannot hold that against you. In the event that you do decide to testify, and even if you don't, the jury's going to look, the judge or the fact finder is going to look to see what other evidence is there to support or corroborate your version of the self-defense claim, right? So if you have injuries that are defensive in nature and you can prove that you were acting in self-defense through your testimony or some other witnesses, in conjunction with that evidence, your defensive wounds can be very compelling to show that there was actual need to defend yourself. Or if you have no injuries and the other party has multiple or really serious injuries, then that's also going to weigh into the assessment of whether your self-defense claim is actually valid under the law, right? Because depending on how the situation evolved, the jury is going to look to see, what injuries the other party suffered, and that will determine if your use of force was excessive under the circumstances. They'll look to see if you were injured and if your testimony or other witnesses' testimony or the alleged victim's testimony is consistent with how you described, the potential injury to yourself or even to third parties. So all of these things are very important in the assessment of the legitimacy and the compelling nature of your self-defense case or self-defense argument. Witness testimonies, bystander testimonies that either corroborate or not corroborate your version of self-defense are going to be, of course, considered by the fact finder, which is the jury or the judge, right? So they're going to see if there are any other accounts of percipient witnesses who may have seen what happened, who lunged at first at the other party, who was using a weapon, what was said, what was exchanged prior to the physical interaction, was there property damage, what types of weapons were involved. These testimonies and accounts from third-party witnesses could be the tie in the jury or the judge deciding whether, your self-defense claim is valid under the circumstances. So the facts do matter, and your testimony is just one piece of it, but the corroborating evidence, whether it's through physical evidence or through other bystander testimonies or accounts, is also going to weigh into this decision or determination whether you had a valid self-defense claim under California law. So the first thing a defense attorney is going to do when they look at a potential claim of self-defense is to assess the injuries, right? Did the alleged victim suffer any injuries? Did you suffer any injuries? And then assess those injuries to see if they're offensive in nature, defensive in nature. They're going to look to see if weapons were involved, if there was any property that was injured, if there was any surveillance that was collected, which could basically show how this encounter occurred, right, between the alleged victim and you as the client. They're going to want to obtain medical records. They're going to want to potentially obtain expert opinions on the types of the injuries that were involved in your case and look at all the core elements that we discussed to see if there could be a valid claim of self-defense. So another thing that your attorney should do is to identify witnesses who may have seen part of the encounter or the entire encounter, who may have heard the incident or statements during that incident. It's really important to identify these witnesses and do a full and complete investigation to gather those statements and make sure that those witness statements are also evaluated in your potential self-defense. A timeline could also be critical. A history of building prior threats and patterns of violence could also help establish your claim of self-defense. These are all things that need to be investigated and documented and compiled for your attorney's review and assessed the right way in terms of how your self-defense fits into the overall picture in your criminal case. So the biggest mistake that people make is that by just claiming self-defense, they're just going to win their criminal case. And that is not how this works, okay? Because self-defense has its own elements, and you have to be able to prove those elements, and you have to compel it in a compelling and persuasive way, show the fact finder, which is the judge or the jury, that you meet the elements of self-defense. And that's why you need an attorney to look at the entire case, the investigation, and the evidence collected in your case, and build your self-defense claim strategically and present it the right way with persuasive advocacy. If you have an urgent need to speak with an attorney, call us at Night Law at 408-877-6177.